Thank you all for your attention. Greetings and welcome to our roundtable discussion, Latin America at a Glance, a political thermometer and key regulatory developments impacting foreign investments. We have some brief housekeeping notes for attendees participating remotely. Attendees will be muted throughout the session. If any questions arise, please enter them in the Q&A function located on the lower right side of your screen. If your question is not addressed during the session, we will follow up with you directly afterward. Following the program, you will receive a brief evaluation survey. We thank you in advance for sharing your insights. And now, from the Global Disputes Practice in Washington, D.C., we are delighted to turn the proceedings over to Maria Pradilla.
Thank you, Michael. Good afternoon, everyone. Buenas tardes a todos. Bienvenidos. Welcome to Jones Day. We are truly delighted to have you here with us today. This event, as you know, is both virtual and in person. I'm super happy to have this event in person because I get to see so many familiar faces and so many friends. But also virtually, we have many people signed up virtually from both Latin America and from the United States. And we thank you very much for taking the time and joining us. This year, for the conference, and given all the recent political changes that are happening in Latin America and that have happened recently in Latin America, our conference will focus on giving a glance of Latin America, and we have called it Latin America at a Glance, a political thermometer and key regulatory developments impacting foreign investments. And there is a lot to talk about with respect to changes in Latin America this year and in the previous couple of years. I don't know that an hour is enough, but we're going to do our very best. This Sunday is the Brazilian elections, and we know that that could change very, very rapidly the environment for investors in that country. We have had regulatory changes or potential regulatory changes in Chile, in Peru, in Mexico. We will try to distill all of this and figure out a way forward for foreign investors in these different jurisdictions. To do that, we have put together and invited a set of experts from each of those jurisdictions that would help us navigate through these changes and point both investors and us in the industry in the right direction. So I'd like to start the introductions, and I want to start first with Melissa Gorslein, who is a dear colleague and the moderator for the event. Melissa is a partner at Jones Day Global Disputes. She is based out of Washington, D.C. She is a member of the firm's Chambers Band 1 ranked international arbitration team. She specializes in investor state and international commercial arbitration, and she has individually been ranked by Chambers US, Chambers Global, and something we in the team are very, very proud of. She has recently been named Law 360's International Arbitration MVP in 2002. To introduce the rest of the panel, I'm going to try to go in alphabetical order for the country, for the jurisdiction. So they haven't sat in that position, so you'll be completely confused as I'm introducing them. But I will start with Argentina. So the first one is Gonzalo Garcia de la Tour. He is a partner at Becar Varela. He has over 20 years of experience in litigation. He heads the firm's arbitration department and co-heads the litigation department. From Colombia, we have, and he's all the way at the end, we have David Ricardo Araque Pinzón. He's also a partner, and he's the Director of Litigation and Dispute Resolution Practice at Gómez Pinzón y Abogados in Bogotá. He has over 18 years of experience in litigation and international and domestic arbitration. Next to him, we have Elena Najar Abdo. She's a partner in arbitration and litigation arbitration areas at Sescam Barril in Sao Paulo, Brazil. She has over 20 years of experience as well in litigation and arbitration. She assists foreign and Brazilian clients. Rodrigo is to the left of Melissa, Rodrigo Zafirio. He is a partner in M&A and corporate department in the corporate department of Bofill Mir in Chile. He graduated from the Universidad de Chile, has an LLM from NYU, and has worked before at the offices of The Voice in New York. One other colleague of ours who is very dear to us as well is Jose Antonio Vázquez Cobo. He is an off-counsel with the Global Disputes Practice in Jones Day in our Mexico City office. He graduated from a Universidad Iberoamericana de Mexico in his JD and has practiced for over 20 years, again, in commercial litigation as well as domestic and international arbitration. And last but not least, Jorge Lopez, who is a senior associate in the arbitration team of Rebasa, Alcazar y de las Casas in Peru. He has an LLM in comparative and international dispute resolution from Queen Mary University in London and specializes in international and investment arbitration. Thank you again, everyone, for being here today in this panel. I'm very much looking forward to hearing you all speak about these issues. And with that, I will pass the baton to Melissa Gorsline. Thank you.
With apologies. We do have a lot to discuss, and so I will get right to it. And I think we're going to start, Helena, with you. You, as Maria mentioned, you have some political and economic climate in Brazil. In particular, as Maria mentioned, we know you have the election coming up on Sunday. So what's happening on the ground?
Thank you, Melissa. Thank you, Maria. I'm truly glad to be here, sharing some of my experiences with such an accomplished group of people. You went right to the point, didn't you, Melissa? In terms of the economy, Brazil has always shown a kind of stability. Regulatory stability, to be more precise, in relation to rules applied to the economy. Of course, we are not in our best moment of our economy, neither in Brazil nor in any other country in Latin America, even here in the States, because of inflation. But there's hope. Brazil is a little bit ahead in relation to other countries, especially because of the central bank policy in order to control inflation through monetary policy, with an increase in the basic interest rate carried out by central bank. As far as the political scenario, it's true, we are having our elections on Sunday, and I'm not gonna clarify anything because we really don't know who is going to win. It's a very tight election. Polls are showing a technical tie between the two candidates. For those who are not familiar, we have the current president running, who is Jair Bolsonaro. He is much more aligned with the right. And we have another ex-president, so we have had both of them already, which is Luiz Inácio Lula da Silva. Polls show that it's going to be the second round is going to be a very difficult to preview the results, and but we do not expect many changes in the economy or investors the environment. Brazil is from the legal perspective, and especially from the dispute resolution perspective, Brazil is an arbitration-friendly country. We are, for example, we have a very sophisticated arbitral community community. We have some of the members of this arbitral community here with us and some of them watching us. So I'm very proud to say that Brazil has always observed and also courts have always observed arbitration clauses. So trying to show that Brazilian is a very arbitration-friendly environment. We also have had a recent survey that shows that Brazil has increased a lot in the arbitration practice. We are second in the number of parties in arbitration. We are in second place in ICC. And we have a very sophisticated arbitration community, but sometimes we have to be, of course, prepared. Clients, of course, must always be alert, make sure they have the both competent international and local counsel, because many times there are local aspects and some discussions. If we have time, we can talk later about arbitration awards being challenged in Brazil. We have to be prepared ahead of time wherever the wind blows.
Great. Thank you so much, Helena. And it sounds like investors have nothing to worry about, regardless of the outcome of the election.
Well, I hope to be right. I hope to be right.
Great. And Helena, if you could turn that mic off just so we minimize the interference.
You use this one. We can share this one.
Yes, we're going to give up on that particular microphone. All right. So Gonzalo, let's turn to you next. What about the economic and political climate in Argentina right now?
Well,
what do investors need to know?
What a tough question. Well, first of all, thank you very much, Melissa, Maria, and all Jones Day for the invitation to participate in this roundtable discussion. It's a great pleasure for me to be here sharing, well, our experience in at least in my jurisdiction. Well, it is not easy at all to answer that quick question in such a few time. I will try to do my best, but let me say that Argentina, contrary to what happened in Brazil, has been experiencing a macroeconomic crisis for long years, mainly because of the increasing of the public debt caused by the constant deficit of the public accounts. And that was also increased by the strict measures adopted by the government during the pandemic. We have a really strict lockdown during 2020 and part of 2021. So we are facing a complicated economic crisis and political, because we are entering into electoral elections. We will have presidential elections next year. And we are facing a lot of internal disputes between the president and the vice president, Fernandez from the Peronist Party, and Cristina Fernandez from the Kirchnerismo. In terms of let's say the complications or the obstacles that we see now in the economy, I have to mention, well, we are facing a really high inflation rates, over 100%. It seems that this year will end in such a rate that is huge. Also, there are a lot of measures and foreign exchange restrictions from the central bank. Any transfer of funds needs to be approved by the central bank. And that is because the lack of exchange currency to face the state obligations. Well, we also have a lot of restrictions with the imports and exports. There is now, last week, the government approved a new system for the approval of licenses. That, well, it still leaves the authority a lot of discretion in the approval of the imports of goods.
That's very
So-
interesting. And you mentioned next year's elections.
Yes.
Are there any important issues for foreign investors that will be on the ballot? In other words, do you expect the elections to bring change?
We hope so. We expect so. We think that the oppositions, according to the consultants, political consultants and experts, they have good chances to win the next elections. Well, of course, we have a long year ahead, so we will see what happens. But if the opposing party wins elections, we believe that we will have a better condition for investment in Argentina. And
Great.
of course, there are a lot of, then I can talk about the different areas or maybe key areas of opportunities in Argentina.
Yeah, I would love to come back to that later.
Yeah.
I want to give everyone a chance to tell us about the basic climate in their respective jurisdictions, though. So now let's move on to Peru and Jorge. Peru has a fairly new president, and I think many people have been very interested in the direction that the country may go with this new administration. Do you have a sense of what the new administration is doing with respect to foreign investment and what its primary policy goals are going to be?
First of all, thanks so much for giving me the chance to be in this panel. It's so important for me to be alongside some experienced lawyer in their respective countries. Thanks, Maria, also. I think it's a good question. I will address first that if the question is just if there is a political reform in Peru which is pushing any regulatory measure against to be in front or actually to try to damage the investment, the simple answer is no. But the government is still trying to apply some political reforms. Actually, there is a political proposal to change or to modify the Article 62 in the Peruvian Constitution. But if I have to address just a question as what is Pedro Castillo doing in Peru, he said, I'm gonna renegotiate the contract. The first question which came to my mind at specifically this topic is it valid to renegotiate the contract? I think it's just an administrative or civil law matter. But yes, as a will of the parties, if it's valid to renegotiate the contract, if the party wants to renegotiate, there is nothing bad in this proposal. But what happens if the investor does not want to change the contract? You have international cases, landmark cases on that. For example, the Czech Republic against Saluka or other important cases on that, which state that if the government want to change the legal field, probably there is a breach of legitimate expectation of good faith. What investors are going to do with that, it's going to depend on the investment treaty, the applicable investment treaty. It's going to depend on what other measures are taken against the investors in the country. Specifically now, there are a couple of, I was just reviewing some news, there is a couple of proposal, actually no proposal, people is going through that point. For example, Camisea. Camisea is the most important gas field in the country, and there is probably they will be implemented some measures against Camisea or try to renegotiate the contract. Another measure is about for example, the last elected Lima's mayor states a couple of weeks ago that probably are going to renegotiate some transport contracts or other contracts. So what I can foresee in my country, specifically for the next years, I think there is uncertainty for sure. It's not going to be easy to address these topics. The analysis, as a good lawyer should be, it's analysis case by case.
Yeah.
But I think what it is state now, there is not an approved measure against investor. It is set. It's going to be at least in the next future.
So it sounds like, Jorge, and I'm afraid we do have to move on, but it sounds like investors' worst fears have not materialized, but everybody should keep their eyes open for what's going to happen tomorrow. Is that a fair assessment?
Absolutely.
Okay, great. All right, let's move on to Chile and Rodrigo. So we recently had the very exciting and I think somewhat unexpected referendum in Chile where the new constitution was not approved. So obviously some very interesting things happening in your jurisdiction. What do you expect to happen in 2023 in terms of this new constitutional process?
Thank you, Melissa. Thank you, John. When I arrived here, I said to Melissa that if I would have heard that question in the middle of 2019, I would have, or at least to the wrong country, because come on, we don't deal with new constitutions. But we did. Start in November 2019, after massive and several protests due to the increase of the subway fare, as any protest usually start. And the way that the political parties find out in order to get rid of the protest was, let's start a new constitutional process in order to have a new constitution that may allow us to take care of the demands of the people, social care, health, housing, etc. So we elected an assembly in 2020, and they proposed a new constitution this year in July, which was massively rejected, 62 against 38. There are many reasons why probably the constitution was rejected. Nobody knows exactly why, because the bill actually tried to cover everything, even indigenous medicine. So everyone at the end had a reason to reject the constitution. Probably that's the reason why it was 62 and not 51 or 49 or whatever. So basically the project was rejected. So currently now we are dealing with the old constitution. But there is a consent among the different government, left parties, right parties, the Congress, etc., that we need to start a new process all over again. So we are going to start a new process. I thought when I got the invitation from John State that at this moment in time, we will have at least a timeline for the new process to begin. When it's going to begin, who is going to draft the new constitution, etc., etc. But we have nothing yet. We only know that the political parties are currently negotiating what is going to be the process and what are going to be the borders. The main difference of this process against the previous one was that the constitution that was rejected, the main principle was that it should be drafted from scratch with one or two boundaries, basically that we're going to be a republic and not a monarchy and something like that. But now the issue is that we need to find some borders in order to a constitution to be approved. Nobody wants to lose 1 year or 1 year and a half again trying to find out when it's going to happen at the end. So currently for investors, my guess, and I don't know whether it's a guess or a hope, is that we will have probably a new constitution in 2023, more likely to be a mild one vis-a-vis the one that was rejected, and probably something addressing the social request instead of having deep economic reform or deep economic investment potential, poison pills to be.
So your view is that whatever happens in 2023, it probably won't be as radical as what was attempted in 2022.
Yes, I guess.
So a little bit of relief for foreign investors.
At least.
Okay.
Hoping.
Great. All right. Now let's talk about Colombia. David, oh, excuse me. I skipped to Jose.
So I prepared a list of the main regulatory issues that come to mind immediately. Of course, the flavor of the last 2 years have been energy, particularly electricity. Fortunately, the worst fears did not come true. Of course, there have been attempts to change the dispatch rules to the national electric grid, to give preference to older public infrastructure, more polluting, less cost efficient. That was one concern. Number two is they are giving access to that old government infrastructure to issue clean energy certificates, even when those are plants prior to the year 2014 that were legally prevented from issuing those kinds of certificates that prove that companies are using to some extent clean energy to produce energy. Now, the third issue regarding the electricity market is the attempt of revoking self-supply and independent production permits. Those efforts, if we have to take a silver lining from them, is that Mexico has proven to be a country of institutions where the Supreme Court avoided any kind of constitutional reform to make the participation of foreign investment only allowable up to 46% of the electricity market. The Supreme Court said this is not for me to rule upon. The legislative did not approve that. Sorry, the court, what did not approve was to declare federal tribunals have either suspended these attempts to change the dispatch rules, to change the permits, to change the clean energy certificates. The court said this will not go forth. Lower federal courts have still competence to rule upon this. Unfortunately, those courts have either suspended or given the full protection of the law to avoid the implementation of those reforms.
That's very reassuring to foreign investors.
On a second issue that has to do with regulatory affairs, it's this month's or this couple months declarations of the president that were previously issued around May, that he wants to dissolve the Electoral Institute of Mexico, which is one of our most cherished institutions, and he wants to turn it into a direct election organism, which is, of course, not good because you need specialized people in such an independent organ that is directly confronted with López Obrador. Also, we have the lithium issue. A huge reserve has been found in the state of Sonora, and immediately a declaration was issued that it's strategic, that it's for the patrimony of next generations of Mexicans. And the question is always the same. Okay, you have the resource. How would you exploit it without foreign investment? So we need to find that balance where we give love to investment, and investment complies with the new compliance requirements, legal requirements, and we have to find that. We also have the outsourcing reform, which had the best intentions, but it has proven complicated to implement. It was implemented to avoid companies to not recognizing employees as such and give them all the benefits that they are entitled to. But in the implementation, it's really, really a burden for companies to take all that administrative load and to maybe have to fusion two companies, the operating one and the other that only have the employment issues into one with all that it entails.
Well, it sounds, I'm sorry to cut you off, Jose Antonio. It sounds like there is quite a bit we could be discussing in Mexico today, but let's just say it continues to be a jurisdiction where foreign investors should be paying very close attention to new regulatory and political risks that could arise at any moment. Turning now to Colombia for real this time, David. You also have a new government, and it has seemed, at least from what I've read in the press, that there has been expected some new developments to be arising with respect to foreign investment in Colombia. Do you feel that the new government is inspiring confidence in foreign investors, particularly with respect to its new approaches to renewable?
Thank you, Melissa, and thank you to the Joint Day team. We are far behind the discussion as they had in Mexico. Just hearing my colleague in Mexico, I mean, I think those discussions are to be kind of held in Colombia, because we are kind of in an uncharted waters, because traditionally Colombia has elected some right or center governments. Right now we have a left-wing government. And the first thing that this government said when this new president was running for office was that Colombia must sort of change the vision on fossil fuels and then start moving towards the renewable energies. And that imposed a lot of pressure on on the oil and gas industry, because one of the tweets and statements from the government was that the exploration and production contracts that were in place were to be, or at the beginning, of course, suspended. Now they changed their mind. It was like two days or 3 days ago, they said that they abide to the contracts that are in place. But in addition, they were strong and strongly advising companies that the pilots to do fracking in Colombia would be suspended. That is one of the main issues that in Colombia is affecting foreign investment. And of course, there are companies that invested a lot of money in those pilots to conduct fracking in Colombia. However, these statements from the government leads towards a no end and no production through the fracking industry. And let me just bring you some sort of statistics that kind of shows that Colombia was moving towards the renewable energies even before the new president came to the office. More or less 54 projects in renewable energies were kind of conducted from 2018 to 2022. This, of course, means that regardless of whether we are at a strong sort of fossil fuel consumer and production country, our governments have tended to put some kind of pressure, to put a lot of incentives to companies to go to Colombia and invest in renewable energies. However, this current sort of president is saying that oil and gas industry cannot move forward. There are not going to be more licensing on fields in order to exploit the resources that we have in place. And that, of course, will bring us a big question regarding whether Colombia, how is going to substitute these exports that we have in place from the oil and gas industry. We are having like 54 or 57% of exports from Colombia are derived from the oil and gas industry and the mining industry. However, if we stop, as the government has said in previous kind of statements before the Congress, if we stop that oil and gas industry, I mean, we need to find any other resources to substitute that export. And of course, the oil and gas industry contributes to the 3% of the GDP of Colombia as well. So it is kind of a pretty concentrated economy on the oil and gas industry. However, with these statements, we are sort of dealing whether the investors are going to, for instance, go and apply and activate the BIT's treaties that we have in place. Because traditionally in Colombia from, 10 to 12 years ago, more or less the 70% of claims based on investment treaties are based on the oil and gas industry. And those were when we had right-wing presidents or center presidents. Now what would happen if we have this left-wing president?
It very much sounds like Colombia is another jurisdiction where foreign investors need to be paying very careful attention right now.
Exactly.
Well, I thank you all for setting the stage with respect to the political and economic environment in your respective jurisdictions. And now I think I'd like to delve a little bit into how foreign investors might be able to protect their rights and what that dispute resolution system looks like for each of your countries. And so let's start, Rodrigo, with you and talk a little bit about Chile. Are there any key issues that were initially included in the proposed new constitution, which of course did not pass, but were there any issues that, even though the new constitution didn't pass, seem like they're still live and could be the subject of new laws that could come into effect in the short term?
Okay, since the proposal was drafted from scratch, we had the chance to discuss everything. So that was the opportunity to bring experts and people and gather people that did not used to talk about many issues. So definitely social rights, that's an issue. Probably it's not the key issue for investor, but social rights is going to be at the end the most important part of the issue that we need to address. But there are other issues, pension funds also, which is a very important issue in Chile since it are the main players in the capital markets. So nobody knows at the end what's going to happen there. But I foresee that for sectors as mining, environmental, and water protection there are going to be big changes, or at least some changes. There is a common understanding that we have an old regulation, old legal framework about mining and environmental and water. We recently passed a new water code, but that water code is in a lower legal level than the constitution. So probably the new constitution will have to deal with this new water system and try to create a system that incentivizes the companies in order to protect the environment, in order to deal with the communities and start making projects that can make the industry to take care about the future. I want to just read one phrase in the constitution that was rejected about mining. So the proposal stated that the exploitation and use of mining should take into account the finite, unrenewable, and intergenerational public interest of the substances. So probably something we'll have to start dealing with those type of principles in order for the investor to start taking care of mining. Definitely climate change, it's an issue. It was specifically discussed in the constitution as a principle. We recently passed a climate change law, taking the principle of the Paris Convention into the internal legal system. So we have a strong legal framework dealing with that, and parity, definitely equal participation of men and women in all types of bodies, including the constitution, will definitely be a principle also.
So it sounds like there are definitely legal changes likely to materialize that are going to lead to disputes in the future. In
Probably.
Yeah, interesting. All right, Peru. Jorge, have there been any constitutional reforms in Peru proposed by the new administration that you see impacting future investments?
As far as I was checking for this conference, I could identify at least 3 reforms or proposals to reforms, specifically to Article 62, and they are intended to modify the Constitution, which cause a couple of problems, I think, from my point of view. One is juridical, and the other one can be commercial. From the juridical point, I'm part of my law firm as the arbitration team, so probably I'm part of the problem when the conflict arises. But we have another part which is commercial, and it's also important because from the juridical point of view, I can say that there are a lot of cases where Peru was part where relies on Article 62. For example, just thinking on Duke Energy against Peru, where the tribunal went further and states that even what the administrative authority were thinking when launched a resolution was part of legitimate expectation as a fair and equitable treatment. So if a change of Article 62 of the Constitution is approved, could be a very high risk to the investors in my country. And thinking on a commercial thing, I cannot say that our president our current president, because we had 5 or 4 presidents last year, is going to denunciate the exit convention, but it follows the same tendency. I cannot say that it's going to happen in my country, but there is a risk, there is a threat, a continued threat to denunciate the exit convention, which can cause any other problems, which you may know, for example, Fábrica de Vidrios against Venezuela, or when the denunciation comes into effect. There is a political risk over there. I can say that also before to start this conference, I checked anew when the Lima's mayor wanted to review or renegotiate some toll contract, which is also a problem from my point of view. Just to make a quick summary of what I'm saying, I am not an economist specialist. I don't know why my country is continue developing and growing economically. If you can say the numbers are white and black. It's just a matter of Peru is still growing, but I'm not sure if the stability follows the same tendency, because some investors can be aware of their respective contracts or even their treaties. I cannot say that a contract may not be breached in the future, or probably, as I stated before, fair and equitable treatment or good faith under the treaty claims.
So it seems like Peru is another jurisdiction where we can expect disputes to arise, and that investors should be considering what their rights might be and how to protect them. Fair?
I'm going to answer the same as I did before. Absolutely.
Okay. All right, David, let's talk a little bit about Colombia. Now, you mentioned this earlier. We have seen the new central government in Colombia sort of inserting itself into various issues through Twitter. And you made reference to that earlier. Now, this is fairly unusual, as I understand it. And how is this informal participation by the central government into these types of issues online and on social media likely to impact the foreign investment climate in Colombia?
Yes, that's a good question, Melissa, because we have seen in the past kind of a couple of months that our president is using Twitter kind of constantly in order to make some statements and opinions regarding, for instance, the central bank decisions regarding the interest rate, or whether certain decisions from or statements from the finance minister are correct or it should be changed, and so on and so forth. And this is a quite rare, and there is a very important newspaper in Colombia called El Espectador, who a couple of weeks ago issued a kind of information regarding the Ministry of Finance, which is called the adult in the relation within the government. Because sometimes whenever the Ministry of Mines or the president goes to Twitter, stating something regarding the central bank, stating regarding how the government is going to pay some landowners regarding the expropriation, if so. So then the Ministry of Finance go publicly and said that there's no decision regarding that issue, that there are some kind of strong institutions in Colombia, like the Constitutional Court, that would, of course, review those sort of decisions in the near future and probably would reverse it. So it was kind of at the beginning of this year that JP Morgan conducted a specific study and analysis regarding how those tweets would affect the economy. And of course, for instance, regarding the decision from the central bank to increase the interest rate in order to tackle the inflation, and then the president said that that was not correct, that probably it would suit best to impose temporarily sort of tax to certain investments, and then of course along and among other factors that resulted in the increasing of the exchange rate peso against dollar. So it was kind of it was absolutely shocked for the economy in Colombia regarding how these specific statements from that kind of a social media, which is being used as of today, pretty hard from the side of the government, inflicts some damages and hurts the economy, Colombia. So of course, in addition, for instance, at the beginning, and I will close with this sort of a statement, the president, and when he was a candidate, said something about Ecopetrol, which is one of the biggest companies in Colombia. Oil and gas industry moves the economy pretty far ahead. And it says that, of course, the boards of directors of Ecopetrol must change first. And second, that the moving towards a renewable energies is a must for Ecopetrol. And then, just for that statement, the shares of the Ecopetrol lost value.
Well, it sounds like everyone invested in Colombia needs to be monitoring Twitter if they are not already.
Exactly. Actually, they requested the president not to use Twitter anymore, or to be kind of a measured.
I think the United States tried something similar a couple of years ago.
Exactly.
It didn't work.
Exactly.
So best of luck to you. All right. Let's move on now to Argentina, Gonzalo. So we've heard, you occasionally hear rumors about Argentina's local courts not being particularly arbitration friendly, that Argentina is not a particularly safe venue for submission of disputes by foreign investors to international arbitration. Do you agree with those comments?
Well, you know that in Argentina, we renew all the legislation regarding arbitration, domestic and international arbitration. Domestic arbitration is regulated by the local procedural codes, and in 2015, it was enacted the new Civil and Commercial Code that introduced substantive laws regarding arbitration. It regulates the contract, arbitration contract, contrato de arbitraje, and then that was an important improvement on all the legislation regarding arbitration. It recognizes quite standard international principles like the competence, the separability of the arbitration clause, the independence of the arbitration agreement, and it also recognized the power of arbitrations to grant preliminary measures and injunctions. So this is in terms of the domestic arbitration. Regarding the international arbitrations, in 2018, it was enacted the International Commercial Arbitration Law that regulates all the international commercial arbitration with venue in Argentina. This is also an important improvement on the matters, and it follows the model law, UNCITRAL model law on arbitration, on international commercial arbitration. Clearly, this modernization of the Argentine legislation concerning domestic and international arbitration makes Argentina a safer and more attractive venue to solve disputes through arbitration, especially commercial disputes.
That's wonderful news.
Yes, and we noticed that in the last years, there is a clear trend from the local courts to reject any attempt to review the merits of the awards when the parties waive the right to appeal the awards.
Great, that's excellent news. And similarly, Helena, with respect to Brazil, you hear similar thoughts articulated, particularly that Brazilian arbitration awards are frequently challenged in local courts. Do you find there to be any truth to those statements?
The arbitration awards are less challenged than the media reports seem to.
Fake news.
Yes, it's some kind of fake news, and I brought some data here to you. I've been working for more than 15 years with foreign investors and foreign clients, and always we have the same question. Is arbitration or arbitrators in Brazil reliable? Yes, they are. And the numbers showed that to us. The main concerns are costs, duration of the proceedings, confidentiality, and reliability of arbitration, and they are arbitration in Brazil is reliable. Of course, first of all, the Brazilian Arbitration Act from 1997 provides very limited grounds, very, very strict and limited grounds for challenging the arbitration award. And every time these grounds are lawyers try to broaden them, courts have been acting firmly in favor of the law. Also, there has been research from 2016 and to 2022 in the main arbitration centers in Brazil, which are São Paulo and Rio de Janeiro. And from all of the awards that were challenged, all of the lawsuits challenging arbitration awards, only more than 80% failed. So they received a negative result. But this doesn't mean that all arbitral awards are challenging. I have been searching for data, recent data, and I couldn't find, but it seems that data until 2020, which is not so updated because we had the pandemics, and the pandemic really changed this scenario, show that less than 5% of the awards are actually challenged before local courts.
That's great news.
So if less than 5%, and now, and we have a data from September of this last month, 89% of the local courts decisions are in favor of maintaining the arbitration awards. So I don't know how to do the maths because I'm a lawyer, but if less than 5% and almost 90% remain the same, you are going to see that it's a very, there is, of course, we have problems in Brazil and we have problems in local courts, but I think that we have very reputable arbitrators, and we have been experiencing the observance of the law by local courts.
That's wonderful. And is it safe to say that whatever the result of the election on Sunday, that won't change?
I hope so. I hope so. There's a bill that is trying to change some of the aspects of the Arbitration Act, but the congresswoman who presented the bill, it was voted out of office. So now, if nothing happens until the end of the year, and all the arbitral community is working for that, because everybody is against this bill, then I hope that the situation is going to remain the same and even improve.
Great. I hope so too. All right, Jose Antonio, last but not least. It is no secret that lots of disputes have arisen since President López Obrador took office. And so in your experience, what has the Mexican government's approach been toward arbitration? Does Mexico remain an arbitration-friendly jurisdiction?
I think it definitely does. Our system works. We have a 30-year tradition in arbitration. I don't know if compared to other countries, that's a lot or very little, but it started with legal reforms. Now, in the last decade, it has reached a constitutional level, and it's constitutionally protected. Awards get enforced all of the time. I have very few cases, for my personal knowledge, in which awards are set aside because we have sufficient judicial assistance, we have minimum intervention. Also, the judiciary has very clear that the standard should be only due process issues, never the merits. And we have a very good system of commercial arbitration, and would say that also regarding investment arbitration topics, are taken seriously by the Mexican government as a passive and active subject, because when being active, they have really prepared attorneys at the Secretary of Economy to intervene in those matters. They pay their awards, and I say that our system protects arbitration. Now, when it comes to investment arbitration, it's important to tell you that Mexico has a substantial number of BITs, and they are substantially different, especially in their fork in the road provisions. Some of them totally prevent parallel judicial proceedings. Some of them allow them for interim measures. So clients and investors need really to retain competent counsel in both sides, at the investing country and from the investor's perspective, in order to be prepared not only for disputes and challenges, but for opportunities. The investors need to do their homework in advance to any potential case, especially because of those fork in the road provisions that have proven tricky in the past for a lot of investors and companies.
That I can tell you from my experience in my own practice that is certainly true. Some of those Mexican fork in the road clauses can be quite stringent. So with that, we are unfortunately out of time. I personally wish I could stay and pepper our esteemed colleagues with questions all day, because I think so many exciting things are happening in almost all of their respective jurisdictions, actually all of their respective jurisdictions. So I would like to thank you all for being here today. We didn't have any questions, right, in the chat room? Do we have any questions from the room? I know those of us who are joining online probably want to disconnect, but if you'd like to stay on, we do have some questions in the room. So yes.
Preventive of where? Of what? That's exactly the question that we are dealing now, because one part of the country believes that the Constitution does not have any limit in terms of trying to move the things forward. And there is another group that basically says that several of the amendments and several of the potential bills have constitutional constraints that limit the possibility of any amendment. And we have a quite story of that. Many different bills in the past have been dealing with the Constitutional Court once the bill has already been approved in the Congress. So basically the precedent is that probably there are some sort of limit that can restrict the possibility of several amendments. So, but that's a discussion now. I strongly believe that during November we will have a timeline. There is no more time for that.
Yes, hi.
Eu have a de segurança similar to the juízo de amparo. There are some attempts in Brazil to use mandado de segurança as a means to access courts during arbitral proceedings, and then having those courts interfering with, for example, interlocutory decisions made by arbitrators. Fortunately, those attempts were firmly repealed by the courts. Do you face the same problem in Mexico?
No, in Mexico, I would tell you that judicial intervention is actually minimum. I do not tell you with this that companies and their attorneys do not attempt to do those kinds of things, but the judiciary is usually respectful of the arbitration. It sends everything to the arbitral tribunal, and only in the express cases provided by law, they provide interim measures, they provide assistance, they provide whatever the law allows, but it's not like a back channel. It's like, especially for assisting in interim measures, always conservative measures, never innovative measures that can imply some kind of opinion on the merits of the final case. So I would say that in Mexico, we do not have that problem with the authorities. We do have it with some attorneys and their clients. But, yeah.
I'm so excited we have so many questions from the audience, but I just want to state for our online participants that if you do have questions that you would like to have answered, you can still put them in the Q&A session, or you can connect with any of us at Jones Day by email afterward, and we will ensure that the relevant panelist gets an answer to your question. So with that, let's go to you first. Thank you.
I have questions for Rodrigo as well. I understand that in Chile, we discuss constitutional process and everything else is arbitration act. I think there were some thought about changing arbitration, or at least as far as the law of arbitration regarding state entities. The Constitution was not successful. But I was wondering whether you think this is something. I think the discussion regarding the rules of arbitration is coming again in the new constitutional process, or something that's perhaps already.
As far as I remember, the arbitration issue that was discussed during the constitutional process was internal arbitration in terms to prohibit mandatory arbitration for certain issues, not investment state arbitration. So the constitution did not deal with that. So if that constitution did not deal with that, it's most likely that the new one will not deal with that either. So probably that's not an issue that we will face in the future.
Yes, great. I think we had a question back there.
Try to enforce an international arbitration in Argentina. Usually they end here in the United States trying to enforce the award. So one thing that I've noticed in the past 3 or 4 years is that because the arbitration law is, the international arbitration law is so new, so when they try to challenge the award in Argentina, the courts basically don't do, they don't do what they used to do before. It's like a very passive way to look at it, very permissive, kind of surprising that they now say, no, it's arbitration, fine, I won't do a thing. And sometimes you find really, problems with the award, and it ends in the Supreme Court in something they call the queja, which is not really what you're supposed to do. You're supposed to challenge it with a nullity. But then because the courts are not doing anything in those cases, I'm talking about 4 or 5 cases. I was kind of surprised how nice the courts were with the award. Then they file this queja in the Supreme Court. And it's pretty hard to explain here in the United States to a US court what the queja is. It's not a nullity. It's another kind of review. It's impossible that the queja may somehow nullify the award. How does that work? Do you have any experience with that?
I believe that you are talking about cases or arbitration cases with seat, with venue in Buenos Aires or in Argentina.
Yes.
It's the way that you can get to the local court, at least to request the setting aside of the arbitration award. The queja, what is the queja? The queja is a complaint remedy. And it's a complaint remedy that a party can file before the Supreme Court of Justice when the extraordinary appeal was rejected by the Court of Appeal. Let me say that there are several case law in Argentina that states that the queja, it is not, let's say, an admissible remedy against the awards. Yes, if the party waive the right to appeal the award, the only available remedy would be the setting aside request. Then, and that setting aside request will be resolved by the Court of Appeal. Yes, and if that setting aside request is rejected, then the Supreme Court will be able to understand such a situation. But you cannot file a complaint remedy directly to or before the Supreme Court of Justice. And there are some case law regarding that point.
DITs. So they are including new issues like environmental things where they are actually trying to protect the state. They're bringing more defenses to the state, including, I don't know, human rights protection, environmental. They changed the model of the BIT in Brazil. I think it's the most advanced one for Latin America. Do you see that they are actually going to negotiate those BIT? I don't know if the other countries are changing those BITs, because the new ones really include a lot of stuff that will change the way we're going to litigate in international arbitration in the near future. So do you have any experience? Do you know anything about those negotiations?
Yeah, Brazil is not a signatory of the Washington Convention, ICSID Convention, and this has always been a concern for some of our clients. Actually, we have discussed in our prep sessions something about it, and I'm glad that you made this question, because then we can take the opportunity to talk a little bit about it. There have been some changes actually in the BITs and in internal law. Since the beginning of when Arbitration Act was put in force, public entities and public-owned companies and the state could not participate in arbitration. But then there was a change in 2015 that changed the law, and now there are many arbitrations with the public administration regarding infrastructure projects and things related to human rights and environmental, and every time there is a problem. And there are also, Brazil has also substantive law that can support claims, and that's why I think people are trying to negotiate better treaties and better contracts in order to try to frame something that is not actually consolidated. But I do think it's going to be an advance for the future, and I do think that and it's going well. Of course we do not have such a huge track record, but since 2015 there has been a lot of arbitrations with public administration and the states and governments themselves. And we see that they also they have been, and this is public, so we can control, because arbitration is confidential for normally whenever the parties put that in the arbitration clause and whenever the rules of the institution, the arbitration chamber says so. But with the public administration, it is public. So there is another way to control how things are going. And I really believe this is an advance, as you sense it.
Can I add something on that point? Just brief.
Yeah, of course.
Thanks. Yeah, thinking on the question. So I'm not sure, because I haven't reviewed the bilateral investment treaty you referred before, but I can say that probably they are a consequence of what was stated by Chad Cameron or Baku, which were reports of Amnesty International, because they were related more stabilization clauses on Africa, and they state that even if the bilateral investment treaty state that you can go against the human rights or environmental matter, it doesn't matter if you have the most freezing clause. You cannot freeze the legal system. And what the investor can do with that probably can go by damages. But I think probably the bilateral investment treaty, which are negotiating right now with Brazil, are materializing what was stated before for the case law. Actually, I remember a couple of case law, like Czech Republic against Haluka, where it was stated that you cannot apply the most freezing clause. It only allows the investor to go with damages. I think it's just
Yeah,
a
no, and
brief point.
I would also add that I think, the trend to make human rights and other social rights and social considerations more protected in the investment treaty regime, that has been going on for, I think, quite some time. I agree with you that those changes really are implementing what many tribunals have echoed in the past, right? Which is that the state has to have the right to regulate in the public interest, and particularly those types of public interests that involve the environment and health and human safety, right? Those things that we typically associate most closely with human rights. So I think, I think it is frankly a welcome change to have those issues specifically clarified in the treaties, as opposed to having various tribunals who don't talk to each other and for whom there is no binding precedent pontificating on these issues, which that's not a criticism of the tribunals. They each had to address the claims that were before them. But I welcome these new changes in the more modern treaties, and the fact that both investors and states have a much more specific idea of what the parameters are. When you talk about fair and equitable treatment, that is a great, easy phrase to say, but what does it mean? What does a tribunal have to consider when it applies that phrase? And I think these new modern treaties that really spell out the state's prerogative on issues of human rights and social rights make that challenge easier for everyone who's involved in the system. Do we have any other questions? James is giving me the signal, so I think we are more than out of time. But I really am so happy to have had the opportunity to introduce these colleagues who I have had such a pleasure getting to know. They are fonts of information. I will be peppering them with questions for weeks to come. I'm sure they're all thrilled to hear that. But thank you so much for being here today and for being such an interactive audience and presenting us with questions. We really have had a wonderful time speaking with you all today. So thank you for coming. And I hope you'll stay and enjoy some refreshments.